Can a long-standing practice of giving allowances to government employees be abruptly declared illegal, forcing them to refund thousands of pesos they received in good faith? This case went all the way to the Supreme Court, challenging the limits of employee benefits and the power of the Commission on Audit. What happened next might shock you. This is the 89th case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Hit that subscribe button and get notified about our latest content. Watch our videos to increase your chances to recall these doctrines and concepts. This is the case entitled Hagonoy Water District. Celestino S. Venco Jr. and Remedios M. Osorio vs. Commission on Audit, COA, GR number 247228, formerly UDK 16410, March 2, 2021. In 2012, the Hagonoy Water District, HWD, a government-owned and controlled corporation, GOCC, in the Philippines, released various allowances to its officials and employees, including an anniversary bonus and rice allowance. These allowances were granted based on Board Resolutions No. 009, dated April 24, 1996, and No. 016, dated October 13, 1992, which had been in effect for nearly 2 decades. However, on November 14, 2013, the Commission on Audit, COA, issued 2 notices of disallowance, NDs, disallowing these disbursements. The first ND, amounting to 582.00, covered the excess payment of the anniversary bonus beyond the 3,000.00 limit set by the Office of the President's Administrative Order, AO, number 263, and the rice allowance paid to employees hired after July 1, 1989. The second ND, amounting to 150,000.00, disallowed additional allowances granted to the HWD Board of Directors, citing a lack of approval from the Local Water Utilities Administration, LWUA, as required by Presidential Decree, PD, No. 198 and Republic Act, RA, No. 9286.
Aggrieved by these disallowances, HWD officials, including General Manager Celestino S. Venco Jr. and Division Manager Remedios M. Osorio, appealed to the COA Regional Office No. 3, arguing that the rice allowance had been a long-standing practice since 1993 and that the HWD Board of Directors acted in good faith when they authorized these benefits. They further contended that the sudden disallowance violated the principle of non-diminution of pay, a doctrine that protects employees from reductions in their compensation. The COA Regional Office, in its decision number 2014-84 dated October 9, 2014, denied the appeal, affirming the validity of both NDs. The COA emphasized that RA No. 6758, also known as the Salary Standardization Law, clearly stipulates that only incumbents as of July 1, 1989, may continue receiving additional benefits, such as the rice allowance. The COA further noted that the allowance granted to the HWD Board of Directors was illegal due to the lack of LWUA approval. Unyielding, HWD officials filed a petition for review with the COA proper. In its decision number 2017-486 dated December 28, 2017, the COA proper sustained the NDs but ruled that passive recipients of the disallowed benefits should not be required to refund the amounts they received in good faith. However, the members of the HWD Board of Directors, who actively participated in approving the disallowed disbursements, were held solidarily liable to refund the disallowed amounts. Undeterred, the HWD Board of Directors authorized Venco to file a petition for certiorari before the Supreme Court, challenging the COA proper's decision. Primary issue in the Supreme Court. The Supreme Court was called upon to determine whether the COA gravely abused its discretion in sustaining the disallowance of the rice subsidy and in holding that HWD officials and board members were liable for refunding the disallowed amounts despite their claims of good faith.
Decision of the Supreme Court. The Supreme Court dismissed the petition and affirmed the COA's decision with modifications. The court ruled that the disallowance of the rice subsidy for non-incumbent employees was proper under Section 12 of RA No. 6758. The law clearly limits the continued grant of additional benefits to incumbents as of July 1, 1989, and any payment made to employees hired after this date is considered illegal. Furthermore, the court held that all recipients of the disallowed rice subsidy, including passive recipients, are liable to refund the amounts they received. The court emphasized that mere receipt of public funds without legal basis constitutes unjust enrichment, giving rise to the obligation to return the funds, regardless of whether the recipients acted in good faith. However, the court also noted that the HWD Board of Directors and officers who approved and certified the disbursement of the disallowed benefits were solidarily liable for the refund. The court found that the officials acted with gross negligence and manifest disregard of the law, as RA No. 6758 had been in effect since 1989, and the rules clearly prohibited the disbursement of the rice allowance to non-incumbents. The court concluded that the long-standing practice of granting the rice allowance did not legitimize the disbursement, as no vested rights can arise from practices that are contrary to law. The erroneous application of the law by public officials cannot stop the government from correcting such errors, even if it results in the disallowance of benefits and the liability to refund.
Do you believe that employees should be forced to refund benefits they received in good faith, even if those benefits were granted based on long-standing practices? Share your thoughts in the comments below and save this video to your favorites. Important Doctrines. A. Non-diminution of pay. RA No. 6758 allows only incumbents as of July 1, 1989, to continue receiving additional benefits. Payments made to employees hired after this date are considered illegal. B. Good faith in disallowance. Good faith may excuse the liability of approving officers, but it does not absolve recipients from refunding amounts received without legal basis. C. Liability for illegal disbursements. Public officers who approve and certify illegal disbursements are solidarily liable with recipients for refunding the disallowed amounts, especially when disbursements are made in clear violation of laws and regulations. Don't miss out on more valuable legal content that could save you from costly mistakes. Subscribe to our channel now to stay informed and protected.